Welcome to all C3RF members and friends across the nation and indeed around the world. I'd like to welcome you to another session of In Hot, where we discuss the issues of the day that are impacting the individual rights and freedoms of everyday Canadians. And today we're extremely fortunate to have with us John Carpay. John is the president of the Justice Center for Constitutional Freedoms, and I'll get right into a bio here, and I'll cut away to what is up on his page. And we see that there he is, John Carpay. He served with the Canadian Taxpayers Federation as Alberta Director from 2001 to 2005, advocating for lower taxes, less waste, and accountable government. Called to the bar in 1999, he has been an advocate for freedom and the rule of law in constitutional cases across Canada. Now, as founder and president of the Justice Center for Constitutional Freedoms, John has devoted his legal career to defending constitutional freedoms through litigation and education. He considers it a privilege to advocate for courageous and principled clients who take great risks. And I guess we're seeing that today with Tamara Leach and Chris Barber, and make tremendous personal sacrifices by resisting the unjust demands of intolerant government authorities. In 2010, John received the Pyramid Award for Ideas on Public Policy in recognition of his work in constitutional advocacy. His success in building up and managing a nonprofit organization to defend citizens' freedoms is par excellence. I'll just stop the share there and say welcome, John. It's so good to have you on board with us today. It's a real pleasure and an honor to have you with C3RF.
Well, the honor is mine. I've been watching your organization over the years, and Canada desperately depends on various grassroots organizations. And, we would be if there was only one group in Canada speaking up for rights and freedoms, we would be in even worse shape than we are. Yeah. Different organizations appeal to different people for different reasons. And this is... I've often said, and I do not have any military background, but we are in a state of war. It's not war with bullets and tanks and bombs and planes and submarines and so on, but we're definitely in a state of war, a nonviolent but yet very vociferous struggle to defend our rights and freedoms. And the tools that we use are things like podcasts and peaceful rallies, peaceful demonstrations, issue campaigns with people reaching out to their federal MPs and their provincial representatives. So I really appreciate the work that your organization has been doing over the last few years. And I think you started even before the lockdowns and COVID mess.
Yes, it has been, as you say, it's been years, and it's just an incredible saga. I started writing about individual rights and freedoms, these issues, in about the 2016-2017 timeframe, and with when Motion M103 was breaking the surface back in 2017.
That was that vague notion on Islamophobia without defining it, but saying we're all against this. We don't know what it is, but we're against it, kind of a motion in the House of Commons.
Because basically it accused Canada and Canadians of being systemically racist, of being haters of certain religions. And this is certainly not my Canada, and it's not the Canada I served for 29 years in the military as a fighter pilot and a staff officer. I like to think that I was honored to project and protect the values that are embedded in our charter in peace, and I even took those values with me to war in the first Persian Gulf War with the CF-18 squadron I was with at the time. So for me, it was I felt compelled. I had to do something, and it's I've been doing it ever since. But I must say, the last 3 years. Something has really drastically shifted, and you call it a war. Yeah, I think we're in the midst of perhaps we could call it a cultural war, but I think the charter is at the heart of the conflict, and I think we desperately need people to speak up for it and its fundamental rights and freedoms. Now, I want to talk about 3 specific cases because there's so many things we could talk about, but I'm going to cut away and share a screen and talk about the first one. And that is Pastor James Coates. And we can see that He's a peaceful pastor, held normal church services. The Justice Center for Constitutional Freedom stepped in to fund Pastor Coates' legal defense team. Yourself took an active role in publicly defending Pastor Coates and his congregation. Now, this is what gets me about the whole story, is the fact that he was resisting public health orders, but he only began to do so after complying for many months with the very restrictive lockdowns. Pastor Coates began to notice irrational inconsistencies in the public health orders that allowed some Albertans, including Premier Kenney, to dine out with friends. I remember the whiskey lunch. I saw that on social media, without masks, and shoppers to crowd into big box stores. Here in Ontario, you could go to the LCBO and buy liquor, but you couldn't go to church. All the while strictly limiting Sunday church meetings. Now, this is a success story because you recently gained a win on this one. And could you talk about what happened with this case?
So we filed a statement of claim in December of 2020. So after we'd been, Albertans have been, and all Canadians have been subjected to lockdown measures already for 9 months, filed a statement of claim in December of 2020. The court was disgustingly lenient with the government and actually allowed them 6 months to get their evidence together, which is outrageous when you consider that our freedom of association, basic simple things like being able to have Christmas dinner with your mother or with your son, our freedoms of expression, peaceful assembly, conscience, religion had already been violated for 9 months. And yet the court said to the Alberta government, sure, you have 6 months to get your evidence together. I mean, if this was based on science, the government would have been able to pull together the evidence considering their vast resources, tens of thousands of civil servants, they should have been able to pull the science together within a week, 2 weeks, 3 weeks, and said, here's our evidence on which, here's the scientific evidence that supports the lockdowns, and actually present the evidence rather than claiming that science is on your side, actually put the scientific evidence forward to justify these lockdown measures. In any event, when they finally did produce evidence in July of 2021, it was a lot of charts and models, and there's no persuasive evidence that lockdowns had saved any lives. The claim, yes, thousands of times, oh yeah, lockdowns are saving lives, but where's the evidence that actually shows that? Haven't seen any. So it took in total 2.5 years. We finally got a decision on July 31st, and the case is called Ingram, I-N-G-R-A-M, Ingram versus Alberta. And it was a mixed decision. On the positive side, the court struck down all the health orders as invalid. However, the reason for doing so is actually terrifying, because the court's reasoning was that in its interpretation of Alberta's Public Health Act, the court said that all of these violations of charter rights and freedom should have been carried out only by the chief medical officer, Dina Hinshaw, without any serious input from the politicians. And the reason why the health orders were invalidated by the court, July 31st, was because the court found that the real author was Jason Kenney and the cabinet, and that was the reason. Okay. The other negative aspect is that the court in the Ingram decision said that the violations of charter rights and freedoms were justified, but there's no analysis there in that 90-page decision, and I've gone through all 90 pages. There's zero analysis about how weighing the lockdown harms and lockdown benefits, if any. And so it was an abysmal failure to comply with the charter. The charter requires government to show that any law that violates our rights and freedoms is actually doing more good than harm. Yes. And here the judge says, in this paragraph 492, it's towards the end of the decision, based on a general impression, she believes that the lockdowns did more good than harm. And that's it. She just makes that assertion. And she doesn't look into mental health damage for children and all the increases in obesity and anxiety amongst children. She doesn't look at people's life savings that are completely destroyed because the government shut down their business. She doesn't look at the increase in drug overdoses. She doesn't look at people dying of cancer because the chief medical officer canceled diagnostic procedures, et cetera, et cetera, et cetera. So that's the Ingram decision.
This seems it seems like and not just this case, but it seems like judges, the courts are throwing Section 1 of the Charter out with the bathwater, because there in Section 1, okay, you can abrogate individual rights and freedoms if you can demonstrably justify it's required in a free and democratic society. Now, the other thing I note is that by ruling the way the judge did, it seems like Coates, he won on procedural grounds because the wrong person gave the order to shut down rights and freedoms. I also noted another case that I think you were heavily involved with. It was in Manitoba, where the judge there, you were arguing that lockdowns, and you brought in a myriad of world experts to testify how these lockdowns were egregious and the benefits didn't outweigh the risks. And the judge in that case said, when it came to evidence, he said, well, we have to give the government a margin of appreciation. A margin of appreciation, it tells me that I didn't think it worked that way. I thought the courts were a bulwark against government overreach.
Well, there's a kernel of truth in that.
We have to do with the government. We have to give the margin the benefit of a doubt here, and that seems to me like the wrong way to go. Our courts seem to be on the wrong track. What do you have to say about that margin of appreciation?
Well, that Manitoba decision was also a failure to properly apply Section 1 of the Charter. Yeah. What this judge did and what other judges have done is they have mentioned the evidence put forward by the applicants who are saying that their charter rights and freedoms have been violated. And they might say, well, they had Dr. Joel Kettner, who was the former chief medical officer of Manitoba, and he said this, that, and the other thing. And Dr. Jay Bhattacharya, one of the co-authors of the Great Barrington Declaration, he said this, that, and the other thing. And then the government's expert, Mr. Smith, said such and such, and the government's expert, Mr. Jones, said such and such. So they write about the evidence, but then what they're supposed to do, the judges, is if they want to rule in favor of the government, that's their prerogative as a judge. Yeah. They have to explain specifically why they believe that the government's evidence is better, stronger, more persuasive, and they don't do that. Yes. They, in a best case scenario, they kind of lay out the evidence that was put before the court, but then they say, well, it was the worst pandemic in a century, which, by the way, is not true. COVID was on par with the Asian flu of 1957 and the Hong Kong flu of 1968. Yes. So to say it's the worst in a century is not true. But they say, well, we just the government seems to have a bit of science on its side, so we're just going to defer to government. Okay, yeah. And that's a total repudiation of how the charter is supposed to work.
Well, if we're supposed to have protections against government overreach, it looks like we're not going to get that protection from the courts if they keep on ruling in this fashion and throw Section 1 out with the bathwater. I want to move on to a second case here, and this let me cut away. And this case has to deal with Dr. Francis Christian versus Saskatchewan Health Authority. And this one here, we talk about evidence, about judges having to weigh evidence. And in this particular case, Dr. Christian was suspended from all teaching responsibilities, terminated from his position because he advocated for a precautionary principle, informed consent, and drew attention to the risks of COVID vaccines for children. Now, right there, we just finished talking about evidence. And now we're seeing the evidence is coming out. It's the rubber's starting to meet the road here, and we're seeing that these vaccines are harmful for children. Mother's breast milk is proven to be problematic. We have a case in Ottawa where a detective is being taken to task for actually having the gall to investigate that possibility. You can't even investigate it. So here we have Dr. Christian introducing evidence or suggesting that the evidence is there that we need to exercise precautionary principles, and he's blown out of the water, loses his job. Now, this to me it seems to me like we're talking about institutions. We're talking about institutional capture, because it's not just the education field that is, and the medical fields we're seeing these things crop up where you can't say certain things as a professional. Your thoughts on this particular case?
Well, the colleges of physicians and surgeons across Canada took a radically different approach after 2020 in interfering directly in the doctor-patient relationship and telling doctors how to what to prescribe and what not to prescribe. And prior to 2020, the physician was free to assess the patient and make an individual recommendation. I know a public health nurse in Alberta who, when the vaccine was voluntary, she was told by her physician that because of her health condition, she should not take this vaccine. And that's what he said to her. 6 months later, the government, with the support of the College of Physicians and Surgeons, makes the vaccine mandatory. If you don't take it, you become a second-class citizen. You can't go to the gym. You can't go to a movie theater. You can't get onto an airplane. People were fired from their jobs. Students were kicked out of university. And this is because the college no longer respected the doctor-patient relationship. So this very same doctor who told his patient, who happens to be a nurse, that's neither here nor there, he told his patient, do not, because of your health condition, you should not take this vaccine. 6 months later, the same doctor says, I'm not going to give you an exemption from the vaccine because the college is going to pull my license. Wow. So this is just outrageous that these colleges have usurped the doctor-patient relationship. And frankly, they've proven themselves to be a bunch of anti-science Neanderthals. And I say that because if you're pro-science, then you support the debate and the inquiry. And if somebody else says, hey, I think your position is incorrect, here's why, here's my evidence as to why your position is incorrect. The scientific response is to say, okay, well, let me look at that and, agree or disagree or agree in part. And you have this ongoing dialogue in the search for truth. And so the colleges have repudiated science, and the only science we're seeing is political science.
Yeah, we can't. You can't even enter the debate. You can't even offer an opinion, even though it's the expert opinion. You get clobbered with ad hominem attack. It's just absolutely incredible. So we're seeing in the first case here, we're seeing maybe judicial capture, and now we're seeing institutional capture at the College of Physicians level. What I'd like to do now is go into a third case, and I'll do another screen share to introduce it. And this one here is extremely interesting because it involves your representation of the Honorable Brian Peckford, who just happens to be the last living First Minister responsible for drafting the Charter and patriating our Constitution to Canada. And in this particular case, we see that he was, the case is all about travel vaccinations. And maybe as we discuss this, John, we can bring in Tamara Leach and Chris Barber and Freedom Convoy 2022, very appropriate because they're in the second day of their trial for mischief, because they had the audacity to speak out against these travel vaccinations for truckers. Now, the main applicant in this case is former Newfoundland Premier, the Honorable A. Brian Peckford, who just happens to be a patron of C3RF, by the way, we're happy to say. The only surviving drafter signatory 40 years after the 1982 Constitution Charter of Rights and Freedoms was enacted. Now, in this particular case, I followed this one quite closely because I used to be an international airliner pilot for a Canadian company, and this whole bit about travel really caught my attention. And I must say that during the course of your discovery process, you interviewed some experts who basically, from the government, who said there was no justification for these vaccine mandates. Could you elucidate?
Well, this is a silver lining on the dark clouds because the courts are not properly applying the Charter. They're disregarding evidence. but we have to keep on fighting in the courts and bringing these court battles, because here was a case where federal government officials admitted under oath that there's no medical or scientific basis for
Incredible.
barring unvaccinated. I use the word with my quotation marks, because in fact, a lot of people who did not take the COVID shot are very happy with the polio shot that they got as a baby that actually protected them from polio. So this is not, it's not an anti-vaccine thing. Of course, the Prime Minister Trudeau and others try to say that everybody's an anti-vaxxer, which is not true. In any event, this is why we need to bring court actions, because you force the government to show the whole world how poor and pathetic and unpersuasive its evidence is. And in this case, the federal government officials admitted under oath that there's no medical or scientific basis for these travel mandates. It reminds me of what happened in the Manitoba case that we were talking about a minute ago. The head of the Winnipeg labs admitted under oath that when the Manitoba government was fear-mongering with the, oh, we've got 1,000 new cases of COVID, the government actually knew that at least 560 of those 1,000 people did not have COVID. Yes. And so the court action exposed that the Manitoba government was lying to the people of Manitoba by fear-mongering with these COVID cases, knowing that the majority of these so-called cases were people who did not have COVID.
Yeah, it seems to me the evidence is just it's just overwhelming for the side of your applicants, your complainants, and I had the impression that you came out with such hard evidence, such overwhelming evidence in this particular case, that the government, the courts, everybody scrambled to find a way out, and they came up with a concept called mootness. They said that because the government was changing horses and stopping the vaccine mandates, that this no longer was of interest to the Canadian public. But now we find ourselves, it's fall of 2023, and sure enough, working up in the bullpen is another surging COVID threat that they're starting to talk about, and they're starting to talk about mass lockdowns all over again. So this concept of mootness, did it apply in this particular case?
Well, not correctly. The doctrine of mootness has been around for a long time, and there are appropriate circumstances to apply it. Let's say that there's a separating, divorcing couple, and one of the things they're fighting about is they both want the house, and they both want to stay in the house, but they're going to separate. One of them has to move out. So they go to court because they want to have a court ruling as to which of the two is going to get to stay in the house. Well, let's say there's a big fire and the house burns to the ground. It's completely destroyed. And let's say, they've got their fire insurance policy and they're going to get their $500,000 or whatever their house is worth. If the court action was just about who got to stay in the house, the court will say, okay, well, this is moot. The house is burned to the ground. You got your $500,000 in insurance proceeds. You're going to split it up 250, and be on your way. So it's moot. There's no longer an issue there to be decided. Yeah. It could be the same way if the couple was fighting over who gets custody of the dog. This does happen in real life, by the way. And then the dog dies. Well, now, it's moot. Yeah. It's totally inappropriate for the judge in this case. And I wonder if she was afraid of needing to rule against the government. Yes, yes. Because she doesn't put forward any credible reasons as to why this is no longer valid, when in fact all of these travel mandates can be reintroduced on a moment's notice. And It's also a huge waste of judicial resources, because the government had its expert reports and expert witnesses, Premier Brian Peckford, Maxime Bernier, and other applicants. There were actually 4 court actions, 2 of them supported by the Justice Centre and 2 of them by other Canadians. And so on our side, we had put forward expert reports, expert witnesses. Yes. There are hundreds and hundreds of hours of time, effort, energy, thousands of dollars on legal bills. And it was just a disgrace that the judge declared this to be moot. This is so frustrating. And it just seems to me, in my personal opinion, that when it comes to charter rights and freedoms, they're
they're quite disposable. I mean, as a matter of fact, it seems to me that courts see anytime a charter right comes up as an issue, you see them running away. They seem to be running away. The only time they don't run away, it seems, as if there's a criminal under investigation, or a terrorist. Well, then, if you're a terrorist, well, then a Canadian is a Canadian is a Canadian. But if we're Tamara Lich, and now maybe we can talk about Tamara Lich and Chris Barber in their court case right now, they are actually being called terrorists, and it's just absolutely incredible how the charter seems to be so selective.
We're fighting against an ideology that seems to have infiltrated the medical establishment, the legal establishment. It is a woke ideology. It is an authoritarian ideology that presupposes that we need to be carefully managed like sheep and have the governments do our thinking for us, so on and so forth. But it's also it's very selective. You have a breakdown of the rule of law in Canada when Tamara Lich and Chris Barber get criminally charged for simply exercising their charter rights and freedoms peacefully.
Yeah.
But conversely, we saw the destruction of a statue of Queen Victoria at the legislature in Manitoba in July of 2021, and police stood by and watched. And it was rubber stamped by this was criminal conduct.
Yeah, and what about more than 80 churches across Canada burning to the ground with no investigations, no charges laid, no arrests?
That's a breakdown of the rule of law, because that Queen Victoria statue, whether you like it or whether you like Queen Victoria or not, it is property. To deliberately destroy somebody else's property is criminal conduct. It was condoned by the police, and the Crown prosecutors in Manitoba were totally fine with not prosecuting anybody that clearly committed a crime in public. So I hope, and the Justice Centre is supporting, paying for the legal defense of Chris Barber. We're also paying for the legal defense of Tamara Lich in civil action launched by an Ottawa resident claiming $300 million in damages because she lost a few nights' sleep due to the honking of horns.
Wow.
It's a disgrace that these people are charged criminally in the first place.
No, it seems like such sour grapes and so petty. These $350 million because I lost a bit of sleep, and people were legally protesting. I think it was a legal protest. There was a court ruling, as a matter of fact, during the course of the Freedom Convoy, where an Ottawa judge said these people they have a right to protest, just stop honking. So right there.
And the truckers, that was a Justice Centre, a lawyer provided by the Justice Centre,
well done,
who was handling the case, and we still are handling that case. And we happily signed a court order agreeing to no horn honking at night. In fact, the truckers also like to get a good night's sleep. Now, because it's kind of a grassroots movement, it's not something fully enforceable. So there may well have been some truckers who disobeyed the court order. I don't know to what extent. Certainly Tamara Lich and Chris Barber and kind of the main trucker organizations, they cheerfully signed a consent order to not do any horn honking at night. So that problem went away after a few days.
Yes. This is going to be very interesting next, 14 days or so. I think it's supposed to be a 16-day trial. Be watching it very closely. I know you'll be watching it extremely closely as well, as Tamara and Chris fight for all of us, really, and our rights as Canadian citizens to protest peacefully, to associate with each other, and enjoy our charter rights and freedoms. Now, is there anything the C3RF audience can do to help you chaps over at Justice Centre?
Well, continue to support C3RF. I always tell people, don't move your donations to the Justice Centre from other organizations. There are many good groups that need to be supported, including alternative media, groups like the Western Standard, the Epoch Times, the Rebel, Counter Signal, True North. Support independent media, support the grassroots groups fighting for your rights and freedoms. And if you're in a position to add to that, by all means, please consider the Justice Centre as well. We welcome donations of all amounts. somebody gives us, $10 a month, that's great. You get
Yep.
1,000 people giving you
That's
$10
lifeblood.
a month, and all of a sudden you've got a good income stream.
Yep.
So www.jccf.ca. We also have a free email newsletter called Justice Update, and we send it out only twice a month. And so if you want to be kept abreast of our different court actions, just go to our website. You can sign up for the newsletter as well.
Okay, well, thanks very much for that. And if people are interested in gaining access to the C3RF update, I try to get them out on a regular basis. They can go to CanadianCitizens.org and take a look. They're all there, and maybe join us as we fight the good fight here against what can only be called tyranny. Until then, I know you've got to get going, John. So I'm going to sign off and wish everybody happiness and freedom from C3RF, and I know from the JCCF as well.
Well, thank you very much, Russ. It was a real honor to speak with you, and hopefully we can do it again in future.
Okay, thanks, John.
Thank you. Take care. Bye.